Welcome to the Appendix, where we read the primary sources of the past so that the present can be better understood. Today's primary source, the Virginia Bill of Rights, June 12, 1776. This most famous of the Declaration of Rights of the original state constitutions was drafted by George Mason and adopted with slight changes and 2 additions by the Virginia Convention of 1776. It exerted a wide influence not only in this country, but in France. The article on religious freedom was drafted by Patrick Henry. A Declaration of Rights made by the representatives of the good people of Virginia, assembled in full and free convention, which rights do pertain to them and their posterity as the basis of foundation of government. 1. That all men are by nature equally free and independent, and have certain inherent rights, of which, when they enter into a state of society, they cannot, by any compact, deprive or divest their posterity, namely the enjoyment of life and liberty, with the means of acquiring and possessing property, and pursuing and obtaining happiness and safety. 2. That all power is vested in, and consequently derived from, the people. That magistrates are their trustees and servants, and at all times amenable to them. 3. That government is, or right to be, instituted for the common benefit, protection, and security of the people, nation, or community, of all the various modes and forms of government that is best which is capable of producing the greatest degree of happiness and safety, and is most effectually secured against the danger of maladministration, and that when any government shall be found inadequate or contrary to these purposes, a majority of the community hath an indubitable, unalienable, and indefensible right to reform, alter, or abolish it, in such manner as shall be judged most conducive to the public weal. 4. That no man or set of men are entitled to exclusive or separate emoluments or privileges from the community, but in consideration of public services, which not being descendable, neither ought the offices of magistrate, legislator, or judge be hereditary. 5. That the legislative and executive powers of the state should be separate and distinct from the judiciary, and that the members of the 2 first may be restrained from oppression by feeling and participating the burthens of the people. They should, at fixed periods, be reduced to a private station, returned into that body from which they were originally taken, and the vacancies be supplied by frequent, certain, and regular elections, in which all or any part of the former members to be again eligible or ineligible as the laws shall direct. 6. That elections of members to serve as representatives of the people in assembly ought to be free, and that all men having sufficient evidence of permanent common interest with, and attachment to, the community have the right of suffrage, and cannot be taxed or deprived of their property for public uses without their own consent, or that of their representatives so elected, nor bound by any law to which they have not, in like manner, assented for the public good. 7. That all power of suspending laws, or the execution of laws, by any authority without consent of the representatives of the people, is injurious to their rights, and ought not to be exercised. 8. That in all capital or criminal prosecutions, a man hath a right to demand the cause and nature of his accusation, to be confronted with the accusers and witnesses, to call for evidence in his favor, and to a speedy trial by an impartial jury of his vicarage, without whose unanimous consent he cannot be found guilty, nor can he be compelled to give evidence against himself, that no man be deprived of his liberty, except by the law of the land or the judgment of his peers. 9. That excessive bail ought not to be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. 10. That general warrants, whereby an officer or messenger may be commanded to search such suspected places without evidence of a fact committed, or to seize any person or persons not named, or whose offense is not particularly described and supported by evidence, are grievous and oppressive, and ought not to be granted. 11. That in controversies respecting property, and in suits between man and man, the ancient trial by jury is preferable to any other, and ought to be held sacred. 12. That the freedom of the press is one of the greatest bulwarks of liberty, and can never be restrained but by despotic governments. 13. That a well-regulated militia, composed of the body of the people trained to arms, is the proper, natural, and safe defense of a free state. That standing armies in time of peace should be avoided as dangerous to liberty, and that in all cases the military should be under strict subordination to and governed by the civil power. 14. That the people have a right to uniform government, and therefore that no government separate from or independent of the government of Virginia ought to be erected or established within the limits thereof. 15. That no free government or the blessings of liberty can be preserved to any people but by a firm adherence to justice, moderation, temperance, frugality, and virtue, and by frequent recurrence to fundamental principles. 16. That religion, or the duty which we owe to our Creator, and the manner of discharging it, can be directed only by reason and conviction, not by force or violence, and therefore all men are equally entitled to the free exercise of religion, according to the dictates of conscience, and that it is the mutual duty of all to practice Christian forbearance, love, and charity towards each other. Thank you for joining us for our primary source today on the appendix. We will see you in the stacks.